Hello everyone. This video will talk about the confrontation of La Ponderosa Corporation versus the Republic of Argentina. In order to make an optimal explanation and analysis of the case, we will use the IRAC format that consists on the following aspects: the issue, the rules that are affected, the analysis, and the conclusion. We'll start then with the issue.
In 1989, the Argentine government developed a privatization program for a state-owned company, including the transportation and natural gas developed distribution sector. In addition, the currency convertibility system was introduced. The plaintiff's investment in the privatization was made through subsidiaries they owned at the time, such as EPCA and CIES. Investment made due to the condition offered by Argentina at that time. All the conditions and terms were established through Decree 2255/92. However, in 1990 began to give the economic crisis of Argentina, producing that the condition and terms of the project changed. Plaintiffs argued that the different measures result in the violation of the covenant and in their economic affectation. Argentina argued that it took this measure because of the emergency the country was experiencing and because it had the duty as a state to do so, backed by international law and the provision of a state of necessity. Finally, the tribunal found the Argentine had violated its obligation to accord fair and equitable treatment to the claimants. In 2008, the Republic of Argentina submitted to the ICSID ad hoc committee a request for annulment of the tribunal decision. Committees that determine if decision related to article of their convention should be annulled. Based on Article 52 of the ICSID Convention and steering, the first is the tribunal was over-restricted. The second, serious breach of the procedural rule. And the third, the reason on which the decision is based were not present. The Secretary of the ICSID decided to suspend provisionally the execution of the tribunal decision until a new revision. The plaintiffs request the suspension of the execution of the decision or to allow it for a compensation from Argentina for the wait. These claims were not taken into account. On September 1, 2009, the committee concluded that the tribunal did not overreach in determining that the plaintiffs had U.S. standing to act. The committee rejects the annulment. June 21, 2010, the committee declared the proceeding closed.
As it follows, now we're gonna deep inside the rules that were mentioned and affected in this struggle. In this section of the IRAC format, there was three principal legal struggles in the conflict of Argentina and Enron Corporation. The first one was that regarding the jurisdiction of the tribunal in accordance to Article number 1 of the Bilateral Investment Treaty, the definition of investors applies to the claimants. The second legal struggle was that regarding the breaching of the standard of fair and equitable treatment in accordance to Article number 2A, the Argentine government failed not to alter regulatory approvals and conditions and failed also to provide a stable, predictable legal environment. The last one was that regarding the umbrella clause, the tribunal concluded that the Argentine Republic had breached Article number 2C of the treaty, which emphasizes the protection of the private party has been given against either a later change of mind by state. The next part of this case will be the analysis.
Their rules were applied as follows. The claimants cannot be considered to be only remotely connected to the legal arrangements governing the privatization. They are beyond any doubt the owners of the investment made, and their rights are protected under the treaty as clearly established in treaty rights and not merely contractual rights related to some intermediary. Also, the tribunal concluded that the key element of fair and equitable treatment is the requirement of a stable framework for investment. NAFTA considers also these conditions as reasonable and justifiable. So when the taxes assessed changed the legal and business framework under which the investment was decided and implemented, the rules were broken. Originally, Argentina guaranteed tariffs would be calculated in US dollars and would be adjusted in accordance with the US PPI. Since tariffs had been frozen for 5 years, doubt and ambiguity characterized the financial operations of the claimants. And finally, in the manner that is stated any obligation in the treaty, it must be understood so as obligations regardless of their nature. Through the gas law that attracted investors, the respondents assumed obligations regarding investment. Tariffs calculated in the US dollars converted to pesos for billing purposes linked to the US PPI and sufficient to provide a reasonable rate of return were intended to establish a tariff regime that assured the influx of capital into a newly privatized company such as TGS and assured the value of such investment. The dismantling of these guarantees would suffice to establish a violation of the obligations entered into the respondent with regard to the claimant's investment.
The last part of this case is the conclusion.
To conclude, to the tribunal, it's clear that Argentina breached two major articles of the BIT, the Umbrella Clause and the Standard of Fair and Equitable Treatment article, through the implementation of stamp taxes in the southern provinces where TGS had contracts. The main point of dispute for Argentina lied in the fact that it undertook measures to face several multifaceted crises the country was living through the beginning of the 2000s. It would have been sufficient, this argument, if it were not for the fact that the taxes assessed had been prolonged in a manner that brought uncertainty to the investors, for they were extended continuously throughout the years and they had well been prolonged after the state of emergency. To worsen the case of Argentina, the tariffs have been frozen for 5 years, clearly breaching the arrangements established initially by the BIT.